I'm going to talk to you today about will disputes, which are very much in vogue at the moment. You only have to open the Daily Mail to see yet another article on a big will dispute in the High Court. And of course, television shows like Succession highlight how all over the world families fight over inherited wealth. My name is Klemme and I'm a partner at Quastels, and I have been advising clients on will disputes for over 10 years. I now want to talk briefly about will disputes by covering who can challenge a will, how a will can be challenged, the consequences of challenging a will, and finally an issue that is sometimes overlooked, the specific and often very helpful rules on costs. So if you believe you've been unfairly left out of a will, or you've received a gift that is well below expectations, then buckle in as I'm going to go through the possible ways by which you can challenge the validity of the will. So before we look at how you can dispute a will, let's look at who can dispute a will. The main categories of people are disappointed beneficiaries, and this means anyone who may have benefited under a previous will or who could benefit under the intestacy rules. Secondly, you have close family members and dependents of the deceased, and that means anyone who is financially dependent on the deceased. And finally, creditors, so anyone who is owed debts by the deceased. Now we're going to look at how to challenge a will. In English law, there are 5 main ways to challenge a will, each of which is slightly different. All you need to do to invalidate a will is to succeed on one of these 5 grounds. The first of which is the simplest and the one we always tell clients to look at first, and that is for lack of due execution. Under the Wills Act 1837, there are very strict formalities for executing a will. If those haven't been complied with, then the will is invalid. The second way by which you can invalidate a will is via a lack of testamentary capacity. And this means, did the deceased have the requisite mental capacity to make a will? This is an increasingly common way of challenging and invalidating a will because we are living in a society where people are getting older and they are more vulnerable in the years before they die. Now, the test for testamentary capacity is still based on a very old 19th century legal case, and there are 4 limbs which you must go through. The first one is, did the deceased understand that he was making a will? 2, did the deceased understand all the property to which he was disposing of? 3, did the deceased consider everyone he ought to consider, including those he doesn't want to benefit, and that's very important. And finally, was he or she of sound mind and in possession of their faculties? The third way in which you can challenge and potentially invalidate a will is through what is called lack of knowledge and approval. In a nutshell, a will maker needs to know and approve the contents of his or her will. The classic example, although we see less of it today, is that if someone can't read, well then they can't read their will, and if they've executed it, then they don't have the requisite knowledge and approval. This can be quite an important claim to bring, and it's often brought together with lack of testamentary capacity and undue influence, because if you fail on those 2 claims, you may just about be able to succeed on a claim for lack of knowledge and approval. The fourth major way by which a will can be challenged and potentially invalidated is by way of undue influence. In a nutshell, this means, did someone coerce the will maker to make a will which they did not want to make? So this is a claim that tends to be very popular with clients. However, it is hard to succeed on because making allegations of undue influence is considered very serious by the court, and therefore they set a high evidential bar. For this reason, these claims can also be risky because if you do not succeed, then you will almost certainly have an adverse cost order made against you, which means you will have to pay your opponent's costs. And the reason why these claims are so difficult to succeed on is because you need to have actual evidence of the fraudulent calumnies, and unfortunately, these are usually held by either the person who is being accused or by the deceased who is dead and can no longer provide evidence. The fifth and final major way by which you can challenge and potentially invalidate a will is via claims of fraudulent calumny. This is defined as someone poisoning the mind of a will maker such that they do not benefit someone they naturally otherwise would have. Good examples of this are brothers or sisters or other family members slandering their others to the will maker such that they leave them out of the will. Like undue influence, this is a very hard claim to succeed on. This is because the court believes that allegations of fraudulent calumny are very serious and therefore the evidential bar is high. This also means that, like undue influence, These claims can be risky, and if you're unsuccessful, you are likely to have an adverse cost order made against you. So the next question that clients always need to ask themselves before they engage in serious probate litigation is, what is the effect of invalidating a will? The main effect is that the will you are challenging will become invalid, and therefore the previous will, if it exists, will be valid instead. And if there is no will, then the rules of intestacy will apply. The reason why this is important is because no one wants to go through the expense of challenging a will to find out that a previous will or the intestacy laws still don't give them the gift or the benefit that they are looking to receive. Therefore, you always want to think commercially about whether it is worth challenging a will and what the position will be if you are successful. Before I finish this talk, I just want to go through one final bit, and that is on the matter of costs. Everyone knows that litigation in England and Wales is expensive, and the general rule is that the unsuccessful party pays for the successful party's costs. However, probate litigation can be different. The court may order the costs of all parties to be paid from the estate, and this means that even if you lose, you may have your costs paid for by the deceased estate on the basis that there were reasonable inquiries to be made. And that essentially means, was it valid or was it reasonable to investigate lack of capacity, knowledge and approval, undue influence, or fraudulent calumny? If the court thinks it was reasonable to at least investigate those, up to the point where it became clear that they weren't going to be successful, you may well have your legal costs covered. Thank you very much for watching what is an overview of the 5 major ways by which you can challenge and potentially invalidate a will. However, we always advise potential litigants to seek professional advice early on, as probate claims can be risky and costly. If you think you've got a valid dispute, then please check out our website, in which we have a hub of information which goes into more detail on the topics which I have discussed today. And if you would like to discuss your potential claim with me directly, then please do not hesitate to use our website to book in a free 15-minute consultation. The link is in the description below. Thanks for watching this video, and I hope to hear from you soon.